The boy has heard excuses after excuses, but today she had enough. Two defendants stood before her, one with mountain of past conviction, the other begging for mercy. But her message is clear. You have run out of chances. Watch as Judge Bud delivers a brutal reality check in her courtroom.
Objections to the TAP evaluation state? Defense?
No, Your Honor.
Any witnesses?
No.
Defense?
No, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. He has been able to gain gainful employment. It starts Friday, and it's the back caber boots. Over on Goldfield Road. He has never been on probation before for a felony.
I'm sorry, what?
He's never been on probation before. According to the.
No, I mean, let him finish because I'm looking at I see
Oh,
the,
okay, I was basing, if I'm mistaken, then, I apologize. I'm basing it based on what I find. So I'll withdraw that part.
all right, so what I can tell you is he has been on probation for evading arrest, detention with a vehicle for 6 months, deferred adjudication. A motion to revoke was filed, it was withdrawn, and the case was dismissed. He was on probation for DWI in 2002. Probation was revoked and he was sentenced to 4 months in jail. He was sentenced to 6 months in jail for assault bodily injury in 2003. And also in 2003, 6 months in jail for interference with emergency telephone call. 2004, he was placed on DWI second probation for 2 years. His probation was revoked and he was sentenced to 6 months and 20 days in jail. 2004, he had a criminal mischief, $500 to $1,500. He was given 2 years probation. A motion to revoke was filed. The motion was granted. He was sentenced to 6 months and 20 years. 2024, he was charged with escape. He was given 2 years probation. A motion to revoke was filed. Motion was revoked. He was sentenced to 6 months and 20 days in jail. 2006, he was sentenced for assault bodily injury married to 4 months and 20 days in jail. 2008, assault bodily injury. The offense was reduced and he was sentenced to 60 days in jail. 2009, violation bond or protective order. He was placed on probation and MTR was filed. Probation was revoked. He was sentenced to 7 months and 20 days. 2010, violation bond protective order, 56 days jail. 2014, assault bodily injury. That was a felony. It was reduced to misdemeanor. He was sentenced to 1 year in jail. 2017, assault bodily injury family household, 5 months jail. 2019, criminal mischief, $750 to $2,500. He was placed on probation for 1 year. A motion to revoke was filed. Probation was revoked. He was sentenced to 90 days in jail. 2023, criminal mischief, $750 to $2,500. He was sentenced to 10 days in jail. 2024, terroristic threat causing fear, 80 days in jail. 2005, evading arrest, detention with a vehicle, 12 months state jail. 2010, possession less than a gram. He was given 2 years probation. The probation was revoked. He was sentenced to 9 months in the state jail facility. 2012, assault family second. He was given 5 years deferred adjudication. Probation was revoked. He was sentenced to 3 years in prison. 2014, possession, 1 to 4 grams. He was sentenced to 3 years in prison. And now we are here. All right. Anything you wish to say about your client's behalf?
Other than what I said previously, no.
All right. And state, you had something you wanted to say?
I did, Your Honor, but it's already.
All right. Anything you wish to say, Mr. Pardo?
I am terribly sorry.
You want to raise your right hand for me? Do you
Yes.
solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I swear.
What?
All right, you can lower your hand, state your name for the record.
Joshua Javier Pardo.
All right, you stated there's something you wish to say?
I'm terribly sorry for my behavior. I was on a reckless path. I didn't know. I also suffer from bipolar 1 disorder and PTSD. I wasn't on medication at the time. I have been trying to better my life for quite some time. My family is here in support of me. They have been very patient with me as well as I have tried to.
All right,
better my
I
life.
still don't understand why you went to the Dollar Tree and threatened the employees
I
and
went,
start breaking items.
yes, ma'am. I went, I didn't have my glasses at the time. I tripped over something and I thought I heard her chuckle and I lost my, excited and took over. I knocked over a stand, I believe probably $13 of damage. I was able to apologize to the cash register woman and she had told me that I wasn't allowed back at the store. I am on GPS monitor. I have been obeying everything.
Now, what it says in the stipulations, I'm not the one who accepted this plea, but what it says in the stipulation is that victim said suspect was verbally aggressive with them and that suspect verbally demanded money for an alleged recall of items from employees, victim 1 and victim 2 at the incident location. Suspect then started breaking items inside the store that were valued at approximately $13. Once he realized that he was not going to receive any money from the business. So there's nothing about you tripping over an item. It says that you went to the Dollar General, you wanted refund. They told you they were not giving you a refund. And then you proceeded to destroy items. And then you told them that you would shoot up the incident with the gun. So that's what you stipulated to.
I did say, Your Honor, that's why they did, that's why people ended up getting shot. But I did not threaten to shoot up the store. I have no way of getting a gun, and I'm not that type of individual to open fire or anything.
All right. The court is going to deny your application. The court is going to find you guilty. According to the plea bargain agreement, punishment is to be assessed at a cap of 6 years in the prison. Defense? The agreement is cap of 6. Do you want to speak to the cap?
I think based on the facts of this case, we've asked the court to assess 2-year punishment. Judge.
All right, the court is going to find you guilty. The court is going to sentence you to 6 years in the prison, and the court will give you credit for any time served. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yeah.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. I'll recommend the therapeutic community for you. It doesn't increase the time that you're in custody, but it can help you perhaps with your mental health issues, any anger issues, or any drug issues that you have. You understand? I want you to know that I listened to everything that your attorney said. I reviewed the stipulations, even though I'm not the one who took the plea bargain agreement. And I reviewed the TAP evaluation, and I reviewed your PSI report. All right? So you're gonna have to start improving your life. You understand? All right, good luck to you. R3278 State versus Jared Jesse G. Sanchez. Can I have parties announced for the record for the state? Defense?
Tony Jimenez.
Are you Mr. Sanchez? Counsel, have you received all discovery? Did you review it with your client?
I did and I have.
Mr. Sanchez, did you review the document entitled Application for Deferred Adjudication with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented? Court will find that the state is in compliance with discovery. Mr. Sanchez, did you review court admonishments and defendant's waivers with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
You're charged with evading arrest detention vehicle. That is a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea, you're giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is and he was.
Mr. Sanchez, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain agreement with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $2,000 fine and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it
Yes, ma'am.
and sign it in both places?
Yes, ma'am.
Did you understand by signing that you were waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
None, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. There be a TAP evaluation and 200 hours of community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Okay.
State any evidence.
No objections.
State you may be excused. Did you review the waiver and consent to stipulations with your attorney?
Yes, ma'am.
Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. Court has reviewed the same. The court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
We would like to, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right. Are you employed?
Yes, ma'am.
What do you do?
Age 30.
All right. Do you have any children?
Yes, ma'am.
What are their ages?
She is a month. She just turned a month.
All right. All right, this is what the court will do. The court is going to sentence you to a $2,000 fine that will be probated, 4 years deferred adjudication, regular reporting by Zoom or in person, regular UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. There's field visits 1 time per month for 3 months, 200 hours of community service restitution. 100 hours will be waived upon completion of parenting classes. And I'm also going to order the defensive driving course, and the remaining 100 hours will be deemed satisfied once you've completed that course. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
No.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. To be successful, communication is key. If you feel as though probation is not addressing issues, let the court know. You can come into court. You understand?
Yes, ma'am.
All right, good.
In Judge Boyd's courtroom, patience had run thin. Before her stood a man whose criminal history read like a never-ending rap sheet. Decades of arrests, revoked probations, and repeated offenses. His lawyer tried to paint a picture of a man turning over a new leaf, claiming he had a new job and had never been on probation for a felony. But Judge Boyd knew better. She read out the long list of past crimes: assault, criminal mischief, DWIs, drug charges, evading arrest, and more. Each time the system gave him a chance, he threw it away. This time, the charge was tied to a Dollar Tree incident. The defendant claimed he tripped, misunderstood a laugh, and lost his temper. But the official record told a different story. He demanded money, broke items, and threatened to shoot up the store. Despite his apologies and explanations, the evidence was clear. Judge Boyd denied his application for leniency and followed the plea bargain, sentencing him to 6 years in prison, with credit for time served. In the very same courtroom, another defendant faced a less severe charge: evading arrest. He accepted responsibility, entered into a deferred adjudication deal, and received probation with strict conditions, community service, and parenting classes. Judge Boyd made it clear: follow the rules, communicate, and you'll get the chance to walk free. Fail, and prison will be waiting.